Hello, everyone. The information provided in this webinar is for educational and informational purposes only and does not constitute legal advice. Participation in this presentation does not create an attorney-client relationship between you and myself and/or any of the attorneys at the law firm of Perez PA. While efforts have been made to ensure the accuracy of the information as it relates to Florida law, you should consult with a qualified attorney licensed in the state of Florida regarding your specific legal issue or matter. Please contact us to discuss your case further. Hello, everyone. Good afternoon. This is Erik Perez, and welcome to our webinar with regards to protecting Florida's homeowners' rights. I'd like to start off by introducing myself. My name is Erik Perez, and I am one of the shareholders here at Perez PA. Our law firm is dedicated to representing homeowners against their HOAs and COAs, as well as any other associations that a homeowner may live in. We exclusively represent homeowners. So we deal with homeowner issues and advocate for homeowners and only homeowners. A little bit about myself. I started off my career actually by representing associations. I represented many associations all across South Florida for many years and represented essentially the board. When you represent the association, you take your directions from the board of directors, and essentially you represent that association by taking the directions from the board. So I did that for many years, and I also represented associations within the context of insurance defense. I represented insurance companies that essentially defended and indemnified associations. And shortly thereafter, I found that homeowners need representation as well. Homeowners are oftentimes the one facing the difficult issues that are caused by the association. And about 5 years ago, I made that shift and now exclusively advocate on behalf of homeowners through the litigation process, through the transaction process, through the arbitration process, and everything in between. Our firm is dedicated to representing homeowners specifically against their association. So today's webinar is primarily for the purposes of educating the homeowners and giving the homeowners the tools that they can use to protect themselves against the association. We're going to be talking about specifically what tools are available to homeowners. In addition to that, we are going to be talking about the legislative changes. Just recently, Governor DeSantis signed the new bill that was presented and now is essentially in effect, is a new law. Today, we won't go too deep into that. We'll save it for the next one, but we will briefly touch on what has been occurring as it relates to legislative changes in the state of Florida pertaining to association and community living. So let me start off the PowerPoint here by thanking you all for joining us here today. As I mentioned, our firm is focused on representing homeowners, and we want you all to have the tools you need to combat your association when the association is not complying with their obligations. On the agenda for today, as I mentioned, we're going to be discussing the nuances of HOAs and COAs. Oftentimes, the term HOA is interchangeably used, but HOA is actually something very unique. HOA is a homeowner association governed under Florida Chapter 720. Condominium associations are a little bit different. They're governed under Florida Statute Chapter 718. And there are some differences in the two statutes, more on that later. We're also going to be talking about the Surfside tragedy and what occurred here in the state of Florida and on the beach. Very unfortunate tragedy that had some serious legal consequences for everyone in the state of Florida that lives in an association. We're going to be talking about that as well as we move forward. Maintenance, a very hot topic within the association context. Oftentimes, I'll receive calls from clients indicating that there's been a leak that could be coming from a pipe, and they're unsure who's responsible for it. The association is saying that the homeowner is responsible for it. The homeowner is saying, I don't believe I'm responsible for that. I believe the association should have to repair and pay me as well for my damages. More on that later. Also, we're going to be talking about where things go wrong in the association relationship. We deal with hundreds of homeowners that oftentimes face many different sort of issues with their association, but oftentimes the issue stems from or starts from the same place. And we're going to be talking about that as well. Lastly, there are several questions, several very good questions that many of you have submitted. Now, there's hundreds of questions that were submitted. I unfortunately won't be able to get to all of them, but I will try to answer as many questions as possible at the end of this webinar. Many of the questions had prompts, kind of lengthy prompts involving what's happening in your association and specifically what the facts are of your case. I won't be able to get into too much of that. However, I will be able to answer many general questions with regards to what you can and cannot do in the association context and what law applies in general, situations that may arise. So I will be addressing many of those questions that were submitted. So let's go ahead and jump into the presentation here. HOAs versus condominiums. What is the difference? Well, I touched on that briefly, but before, I want to give a little bit about the history of HOAs and condominiums. So condominiums were actually first developed in Puerto Rico. Okay, Utah became the first state with condo law, and Florida passed the Condominium Act, which is Florida Statute Chapter 718, back in 1963. Okay, and it has been amended many times over the course of the last 40, 50, 60 years. And most recently with the legislation passed by Governor DeSantis. Okay, one interesting and unique fact, condominium is actually derived from a Latin term, con meaning together, and dominion meaning ownership. So it's a very a kind of older concept that's been developed over time. And HOAs were first developed in the 1900s, homeowners associations. Okay, they've rapidly expanded throughout Florida, and more recently today, per capita, the state of Florida is actually the largest per capita as it relates to amount or volume of associations. California has more, but their population is higher. But generally, as it relates to per capita, Florida is number one. So what are some of the key differences between HOAs and condominiums, also known as COAs? Well, number one is, as I described, the governing law. So generally speaking, for an association to do anything, and let's start off with COAs, condo associations. For a condo association to do anything, the board can't just create something because they think it's a good idea and then start to implement that. Okay, that's what the law exists for. The board has to comply with the law. And you may ask yourself, what is the law within the confines of a condo association? Well, it's two things. It's essentially two documents. The law is what Florida Statute Chapter 718 provides. So if you are witnessing or being involved in a situation where the board of your condo association is doing something that you feel may be illegal, the first document you should look at is Florida Chapter 718, and that can be found relatively easily by doing a Google search and typing in Florida Chapter 718. You will see the statute as it stands today. So I would say that is the first area of law to look at if you have an issue with your condo association. The second thing, the secondary legal authority, are what's commonly known as the governing documents. The governing documents are a combination of documents. They're things like the declaration of the association, the bylaws, the articles of incorporation. If you have a question as to how many members there should be on the board of directors, If you have a question as to what you need to maintain and what the association needs to maintain, the governing documents are also a good point to a good starting point in terms of what to review. So under the association, specifically the condominium association context, we have Chapter 718, and we also have the governing documents of the association. Anything that is going to be done in an association needs to be allowed by those two documents. Okay, there is an area of much contention and much confusion that relates to what happens when the statutes are amended as time goes by. You know, for instance, more recently, within the context of 718, the statute has been amended, and many homeowners are asking, well, do we follow the old law? Do we follow the statute as it stands today, or do we follow what the declaration provides? There's something known as Kaufman language, okay? And we'll briefly touch on that later, but essentially Kaufman language provides that if you, as an association, want the new laws to be part of the governance in the condo, then there must be Kaufman language in the declaration. I encourage all of you to briefly research that. There's many resources on it, but it is a key point when identifying whether the old 718 applies or the new changes in 718 apply. Conversely, in a homeowners association, you are governed similarly by the governing documents, but the statute is different. The statute is Florida Statute Chapter 720. Chapter 720 contains some differences from 718. One that comes to mind is dispute resolution. 718-1255 talks about dispute resolution and certain things that need to be or may need to be arbitrated, as well as certain types of disputes where you can go ahead and pursue mediation, and other disputes where you don't need to do either. You may just be able to go ahead and file a lawsuit against your association if they violated the law or the contract. So 720 is a little bit different. 720 requires mediation for essentially almost anything that may arise within the HOA context. So I encourage you to review the differences in the statutes as it relates to dispute resolution. That is something that occurs very frequently and is something that homeowners should know when dealing with a dispute with their association, whether it's 720 or 718. Also, there are significant differences in the maintenance of common elements or common areas within the 720 context, the HOA context. Often you'll find that the HOA is responsible for roads, landscaping, clubhouses, fencing, things of that nature. Within the condominium context under 718, condominiums, generally speaking, are a building that contains several units in it. And so you'll see that the maintenance obligation is more so related to common element pipes. Also, it's related to exterior walls, roofs, and many things like that. So it's important to understand the key distinctions in the maintenance obligations between 718 and 720. That also affects as well as homeowner maintenance obligations within 718. It's going to involve things like your kitchen, your living room, and similarly within 720, it will also involve that. But as it relates to homeowner responsibilities for limited common elements, it's going to be slightly different because things in condos that are impactful are things like balconies. Usually in an HOA, you don't have a balcony, you'll have a patio or a backyard or a front porch. Under 718, it's mostly going to involve balconies and things of that nature. Balcony enclosures are a big deal within the 718 context. Insurance also varies depending on 720 and 718 as it relates to insurance requirements. And also alterations may vary as well under 718 and 720 as it relates to any changes the board wants to implement within the community. So I touched on this earlier, what associations can and cannot do and the limits as it relates to the powers that an association may have. So what can an association do? An association generally has the power to collect and enforce the obligation of the payments of maintenance. The association has to enforce the rules within the community. The association, generally speaking, has the ability to issue fines. Now, one thing to note as it relates to fines, there is a statute directly on point in both contexts of 720 and 718. The association, many times, and I've received many calls on this from homeowners, the association may just send a letter that says, you owe us $2,000. You kept the garbage bins outside of your home too long, and we're going to fine you $2,000. Similarly, within the 718 context, the association may tell you you had too many guests in your home. Let's say, for example, you had some family visit, and there's a restriction on that as to how many individuals can reside in your unit for a given length of time, and the association may fine you several thousands of dollars for that. It's important to know that within both statutes, there are limitations. First and foremost, the association must have an impartial violations committee. So what that means is the board can't just unilaterally be citing people and issuing fines. There needs to be an impartial violations committee that is composed of members that are not on the board. There cannot be a conflict of interest between the two. And in addition to that, there's a statutory maximum. The statutory maximum is $100 a day for up to 10 days. Okay, oftentimes associations will issue a $1,000 fine for something that happened on one day. They cannot do that. The rule is clear. It's $100 a day maximum for up to 10 days, meaning $1,000 if it's a 10-day violation. That is the absolute maximum. There is a distinction between 718 and 720 that is certainly worth noting here. Under Chapter 718, if the association cites you for a violation and ultimately fines you, they're very limited in what they can do to enforce that violation. Essentially, all they can do is temporarily suspend your access to the common elements. In other words, they can limit your access to the pool, they can limit your access to the clubhouse, they can limit your access to the association gym on a temporary basis. So not forever, this is only temporary, and this is what they can do to enforce a fine if you don't pay it. Conversely, in the HOA context, unfortunately, it's very different. The association can actually foreclose on your home if you do not pay a fine. They can tack it on to the assessments, and they can ultimately foreclose on you if you do not pay a fine issued by your HOA. So keep that in mind in dealing with issues with the association, depending on which type of community you live in, whether it's 718 or 720, there are very different consequences to the two. So what can they not do? Well, an association cannot ignore their maintenance obligation. They get to charge you for maintenance, but they also have to complete the maintenance. So many homeowners oftentimes reach out and say the association hasn't maintained the roof in 20 years. The association hasn't completed landscaping, and it's causing several issues. So the association has an obligation to maintain the common elements. They also cannot discriminate. We've received many calls from homeowners where they will tell me, I've installed something in my property that my neighbor had, and I'm getting notices from the association demanding that I remove it, but here's a photo from my neighbor that has the same exact installation. The association cannot do that. That's called selective enforcement. They cannot discriminate. They cannot selectively enforce rules within the community. They also cannot deny you access to records. As a homeowner, you have the absolute legal right to demand an inspection of all association records. Associations are required to maintain all of their documents. And more recently, the bill that was signed by Governor DeSantis and is now part of the law, the bill under 718 now actually specifically says bank statements. So associations under the condominium context, if they are asked for bank statements, must provide to you their bank statements. Also, the board cannot hold secret meetings. Generally, the only exception to that rule is meetings with their attorney. Associations, just like homeowners, are entitled to what's known as attorney-client privilege. And so if the board wants to meet with their attorney, that can be a closed-door meeting wherein they can ask the attorney legal questions and meet outside of the presence of the other homeowners. So We touched on your rights as a homeowner. Essentially, you can demand the association complete their maintenance. You can demand the ability to vote. Associations are required to have annual elections, and you are entitled to vote at those elections. You're also entitled to inspect records, attend meetings, and of course, run for the board. And I want to touch on that briefly as well. I will tell you all very candidly, the number one way to resolve almost every single association issue is to run for the board and become a member of the board of directors. You can empower yourself and you can be present at all meetings involving the association, and you can speak to the other board of directors and let them know your opinion in order to make sure that your opinion is heard. And in addition to that, your efforts are addressed in terms of what you want the association to do. That is the number one way to take control of your association. So as I mentioned earlier, the Surfside collapse unfortunately caused significant loss of life and significant changes in legislation that impacts all homeowners across the state of Florida. So a little bit about Surfside. It was built in 1981. It's a multi-story building. It's on the beach. It was built before Hurricane Andrew. As it relates to building codes and things of that nature, that has evolved significantly over time. And like many aging condominiums, it struggled with repairs, it struggled with reserve accounts, it struggled with the 40-year recertification process. And as a result of that, there were many years of deferred maintenance, many years of waiving of funding, and a lack, generally speaking, of inspections. And it's not necessarily true that all of this was the cause of it. Sometimes unfortunate tragedies happen, but things could have certainly been done better by the board and by the management of that building. And the goal of at least that's what the legislature believes, and the goal of that of the legislature is to try to avoid this from ever happening again. And so what the legislature has done is really ramp up the amount of inspections, the amount of oversight, and the amount of reporting that an association has to do moving forward. So as it relates to structural inspections, they now need to be done every 10 years. There's mandatory reserve studies for critical components. Generally speaking, there's going to be more funding that's going to be required of associations, and I've already seen it, from hundreds of calls from homeowners. I've heard of up to $100,000 in special assessments per unit. That's very rare. That's not common. I've seen maybe a handful of situations like that. Most of the time, you can expect, as it relates to a special assessment, something within the amount of 30, maybe even $40,000 for these sort of structural integrity reserves. But there's no question about it. As a result of this new legislation, there will be increases in assessments, both regular assessments, and some buildings, particularly the older ones, will very likely face special assessments. So look out for that. A bit on that. The statutes, both 718 and 720, have very clear and detailed requirements for a special assessment. Okay, special assessment is not the association sending you an email saying there's going to be a special assessment and this is the amount. There are detailed requirements under the statute that need to be followed by the association for the assessment to be proper. There are both procedural requirements. By procedural requirements, I mean things like adequate notice. They need to provide the requisite time frame. They need to provide the details of the special assessment. So they can't just send you a piece of paper that says there's going to be a special assessment. This is how much it costs. They need to explain why this special assessment is being passed and what it's going to be used for. So be sure to hold your association to those requirements and make sure that they're giving you the statutory notice that needs to be sent. There's also substantive issues, legal issues that may arise within a special assessment context. And what I mean by substantive issues is I mean that certain types of special assessments require compliance with the law, and the law under certain situations requires a vote. So generally speaking, as it relates to material alterations, so things that are not structural, things that are not obligations that the association has to maintain, generally things that are beyond that, things that are material alterations, those will oftentimes require a vote. And your association may bootstrap a material alteration into a structural requirement that requires maintenance and requires the passing of a special assessment. So be on the lookout for associations trying to bootstrap material alterations into general maintenance under a special assessment. That's a very common practice, and it is something that homeowners should know about and should try to prevent. So important deadlines, and some of this has actually changed with the new legislation, as can be seen on the PowerPoint presentation here. Starting in 2025, many of these changes and many of these deadlines went into place. However, by the new legislation, they have been extended. Many of these deadlines have been extended to 2026, and also there's been some exclusions. So the legislature has narrowed the amount of associations that have to comply with the new law. More on that later, and rather more on that on the next webinar that we do, where we will fully explain the impacts of the new legislation that was signed this week by Governor DeSantis. So maintenance responsibilities, who pays for what? This is possibly the most contentious issue rather within the association context. I cannot tell you the amount of homeowners that I've spoken to where the association is attempting to enforce the homeowner to make certain repairs that are not the homeowner's obligation, that are actually the association's obligation. So who's responsible for maintaining what? Well, generally, a homeowner is, an association is responsible for the structural component. So an association is responsible for the roof. If you live in a condo association, they're responsible for the common element pipes. They're responsible for the exterior walls. They're responsible for the elevator. They're responsible for the pools. And within the HOA context, the homeowner context, it's very similar, except it's involving things that are well outside of the home. So things like the roads, the guardhouse, the community pool, the community gym, things of that nature are the HOA's maintenance obligation. It's important to, and I can't stress this enough, it's important to check your governing documents to identify specifically what the association is responsible for, because it will tell you with great detail what the association is responsible for. So before making any repairs as a result of a leak, before paying the association, if they demand payment for some sort of damage that was caused, before doing anything like that, be sure to review your governing documents to identify what you are responsible for and to identify what the association is responsible for. If the association is responsible for something, and as a result of that one thing, your property has been damaged, you have a claim against your association, and we can help you with that claim. Vice versa, if you are responsible for something, and as a result of a leak or any other event, the association's property was damaged, the association may have a claim against you, and you may need to be defended against the association for the claim they are bringing against you. It all starts with what the declaration provides, what the governing documents provide. It is the most important thing you can look at when it relates to these sort of maintenance disputes. Water damage is oftentimes the most recurring issue within the association context. Now, in the condominium context, it's often going to involve burst pipes. So it can be a common element pipe, or it may be your upstairs neighbor's pipes. Determining the cause is going to be very important within these disputes. You need to know where the water is coming from. And once you can identify that, then you can look to your governing documents to identify who is responsible for that water intrusion point. Okay, there's also some gray areas within the condominium context. Oftentimes I'm asked about windows, doors, balconies, patios, and all of those things will be expressed in the governing documents, and every association treats them a little bit differently. I've seen condominium associations where the homeowner is responsible for the windows, and vice versa. I've seen condominiums where the declarations provide that the association is actually responsible for the maintenance of the windows. So look to your declaration to seek clarification on those issues. So one of the most common issues that arises as well involves lack of transparency. And I'm going to give you a tool in a moment that not a lot of homeowners know about, and is one of the most powerful tools you can use to gain transparency and rather force transparency of the association. So before I go into that, some general red flags that you will see within the association context if you have a problematic association. So if your routine maintenance is steadily increasing at a kind of dramatic and unexplainable rate, there's probably some concerns financially that the association will have. So look out for that. Missing financial records are a major issue. Like most homeowners, most associations should have all of their financial records. They should have all of their bank statements. They should have all of their financial statements. They should have all of their invoices. They should have all their contracts with their vendors. So if there's missing records, missing financial statements, that's a big red flag within the association context. Maintenance delays. If an association doesn't have the money to make basic repairs, that could be a red flag. That could be a major issue. Where is the money going if it's not going into the main thing they need to do, which is maintain the common areas? So that is one of the warning signs as it relates to the association. Secret board meetings. I hear about this all the time. You'll hear that the board members met in the board president's unit. You'll hear that they discussed issues, maybe a person who's a friend of theirs may have inadvertently slipped up and mentioned this to a homeowner. They cannot be doing that, and that is a major red flag with the association within the association context. So look out for these warning signs, but generally speaking, the biggest red flag is going to be when they refuse to turn over records. They should, and they must maintain all of their records. The statute says for the past 7 years, and they should turn them over as soon as they are requested by a homeowner. So be on the lookout for that. So as I mentioned, you have the right to request records from the association, but this is the tool I want to give all the homeowners here. You also, within the condominium context under Chapter 718, you have the right to make written inquiries to your association, and the association by law must respond to those written inquiries. So you can write out specific questions for the association, okay, and send them out to the association via certified mail, and they need to respond to your questions, okay? A few things before going deeper into inquiries. Let me talk a little bit more about records inspections, because there's a lot of disputes that arise as a result of an association not properly conducting the inspection process. So first and foremost, they need to give you within 10 days a date to observe all association records. Now, nowadays, most of the time, associations keep records electronically. So they may ask you, what are you looking for? We'll go ahead and email it to you. And if you are satisfied with that, you can do it that way. But you don't have to do it that way. You can say, I want to see everything the association has for the past 7 years, and they must provide you with an opportunity to inspect all association records. You can bring your own scanner. If they do it in person, you can bring your camera phone and take photos of the documents. By law, they do have the ability to charge you if you'd like to make copies of their documents, a reasonable fee. However, If you'd like to go in and take photos of the documents, you're absolutely free to do that. If you're comfortable with them emailing you the documents, you can simply say, send me all the documents for the past 7 years in a Dropbox link or in a Google link. I'd like to observe them all. So you absolutely have that right as a homeowner, as well as the ability to send inquiries. So to touch on inquiries, you can send out written inquiries via certified mail to the association. You can also email them a copy of those written inquiries, and the association must go ahead and respond to your inquiries. They can seek an extension if it requires a legal opinion of the association's attorney. But generally speaking, if you want to know, for example, why the maintenance went up 20% last year, you can send them that in a written inquiry, and they must provide you with a written response to that question. Similarly, you may want to ask the association, is a special assessment being contemplated within the next 90 days or 120 days? And they must answer that question as well as a written inquiry. So you can really put a lot of pressure on associations by submitting these written inquiries in the Florida Chapter 718. And they will have to respond. And that ultimately, if you have a dispute with the association, that can be used as evidence against the association once the matter goes into litigation. They can't change their answer down the line once they've had an opportunity to consult with their attorney before being deposed. They are locked into that answer, and they're going to have to explain that answer at a deposition if you depose their corporate representative. So it's a very powerful tool, and I encourage all the homeowners within the 718 context that are facing issues with their association to submit written inquiries to put pressure on the association and get your questions answered. So as I mentioned, you have the ability to collect the records. More on that in the slide you see in front of you. We touched on all these points a moment ago, so let me go ahead and flip to the next slide. This relates to the inquiries. As I mentioned, the board must provide answers within 30 days. They can seek an extension if it requires the opinion of an attorney. And these are some great example questions. You know, why did the management fees increase by 50%? What is the status of the roof repair project? Many associations have many different projects that are ongoing. And if you want to know the status of that project, send a written inquiry. Go ahead and fire off a written inquiry and ask them specifically what's going on, what's the next step. There is a penalty if the association does not respond to your written inquiry, and it's a very impactful penalty. They lose the ability to recover attorney's fees in future litigation. So if you ask them a certain question related to a certain topic, and down the line it becomes an issue, and ultimately there's litigation, and you lose in that litigation, however, they did not respond to your written inquiry pertaining to that issue, there is an argument to be made to the judge if the association tries to recover their attorney's fees, that they cannot recover their attorney's fees because they did not respond to your written inquiry. So it's a very powerful tool for many, many reasons. Most importantly, for gaining information, but you can also obtain a tactical advantage in litigation by sending these written inquiries. So this is the kind of general formatting that you see on your screen as it relates to written inquiries and how to submit them. You want to address them to the board of directors. You want to specifically ask for records. You want to specifically ask for the records you're looking for. This is what one would look like, and you need to send it via certified mail. One of the very important tools that a homeowner has as well, as I mentioned earlier, the best and most impactful thing you can do as a homeowner within an association is to get on your board. Now, sometimes elections have passed, and you don't necessarily have the ability to win an election because it may have just passed, and you have to wait till next year. You don't have to wait until next year. You can recall the board. And essentially, what you need to do is fill out a recall petition. The Department of Business and Professional Regulation has a standard form. If you Google DBPR recall petition form, you will find their form online. You can print out that form, and you can knock on everyone's door in order to get your petition form signed. All you need is 50% plus one. So if there are 100 units in your association, if you get 51 of the homeowners to sign your petition form, you can submit that to the board. They must have a board meeting and they must remove and replace that board member. So that is a very powerful tool for the homeowners to know about. You can absolutely recall members of the board. There is a time frame for that as well. So look out for that in the statute. I believe you cannot do it if only 30 or 60 days or so have passed from the date of the election. Nevertheless, if 3 or 4 or 5 months have passed and you'd like to recall the board member because the election is too far away, you can absolutely do that. You will want to build a relationship with all the other homeowners and get them behind your efforts. So it's important to build those relationships if you are going to be pursuing a recall against the current board member or members. Association is much like a small government. Okay, as I mentioned, they do have certain powers, but also you as a homeowner have certain powers against them. Much like the Constitution, where a citizen has certain rights against their government, a homeowner has certain rights against their association. And as I mentioned earlier, those are governed under the requisite statute, depending on what type of community you live under. 718 for condos, 720 for HOAs. But you have the right to request records. You have the right to attend meetings. You have the right under 718 to submit inquiries. And you have the right in all associations to recall the board members. These are probably all collectively the most powerful rights that you have against your association. So make sure in the right circumstances to use your rights. The legislature gave the homeowners these rights for a reason so that they can be used to prevent abuses from associations. So keep all of that in mind when facing a dispute with your association. So at the end of the day, I want the key takeaway for all the homeowners here to be that you have rights. You know, you need to stay informed as it relates to changes in the law. You need to know your rights as a homeowner. You need to use the tools that have been given to you by the legislature to enforce your rights against the association, and you need to take action. No one will take it for you. As a homeowner, it's your investment. You are going to be the person that cares the most about that investment. And if your community is doing something that you believe is contrary to the best interest of the homeowners, you need to use all the tools at your disposal to make sure to address your concerns and to try to make changes within the community. So very briefly, this is our law firm's information, Perez Mayoral, PA. We can help you with all of the issues that were described. If you feel as a homeowner you are unable to tackle the association on your own, I encourage you at the very least to reach out to us to set up a consultation so we can discuss your particular issue in a much deeper way. We can go into the nuances of your issue. We can explore the options that are available to you as a homeowner. We can address alternatives and we can find the most efficient and most effective way to pursue your issue. So I'm going to be jumping into the Q&A shortly, but if you would like a more detailed analysis as it relates to your case, this is our contact information. Please feel free to reach out and contact us. We have several attorneys on staff that can provide you with a consultation relatively quickly. Our turnaround time is pretty fast. So if you would like a consultation as it relates to a certain circumstance that you're facing with your association, please feel free to reach out to us. In addition to that, as it relates to the presentation today, my goal is to give you all the most powerful tools against your association. That was my goal today. You know, if you feel this was helpful and if you feel that you may be able to use some of these tools and essentially that this was an informative presentation, please, it would be much appreciated if you could give us a review on Google so that other homeowners know that we are here to help them. It is impactful for the purposes of guiding other homeowners. So if you feel inclined to do that and you feel this was helpful, I invite you and encourage you to go do that and very much appreciate it if you do complete that. So let me go ahead and jump into the questions, the Q&A session. I have several questions. I am going to address them all as quickly and efficiently as possible. Let me pull them up here on my screen. So let me start off with this one. Homeowner asks how to stop a president of an HOA from spending money without board approval. That's a very common issue. So in order to stop a board president from spending money without approval, as I mentioned, the most impactful tool is going to be to get on the board and remove that board president. So if you have an annual election that's coming up, you need to run as a candidate, or you need to have a group of homeowners that have your similar position run against that candidate. If you don't have the ability to do that, the second option is a recall. You want to get 50% plus one of the homeowners to recall that board president so he can no longer spend the association's common fund. If that's not a possibility either, you need to use your tools as a homeowner to investigate that board president and put pressure on that board president. If you're in a condominium context, you can ask for both, as I mentioned earlier, the records. You can request an inspection of all financial records of the association, and you can submit written inquiries. Depending on what he's spending, you may want to ask him, what was this invoice for? Why was this paid? What did this money get used for? Who agreed to do this? Were the other board members in agreement with spending this sort of money? So you can send out written inquiries under the condominium context. Under the HOA context, you can submit requests for inspection of records. So ask that board president for all records pertaining to that money spent. So you can ask for the bank statements where those charges are shown. You can ask for the meeting minutes where those charges were discussed, if they were approved or not approved. And you're going to want to fully investigate it. And if you find that the board president spent the money improperly, so for example, for his or herself, for personal expenses, you can absolutely report that. And there's several places you can report that to. If it rises to the level of a criminal conduct, then you're going to want to report it to the local police department and they will investigate it. If it rises to the level where the board president has breached his fiduciary duty to the homeowner, so not so much criminal, but just very inefficient, maybe a poor decision in terms of spending money, you can pursue what's known as a derivative shareholder action against that board president and step into the shoes of the association and sue the board president as a director and officer to put that money back into the association. That's a very lengthy, very complex process that I'd be happy to discuss with you in more detail. Not enough time for that today, but those are several options that can be pursued. Another homeowner asks, selective enforcement, how to prove your case? Very good question. So the answer is simpler than you would think. In order to prove your case, you need to have evidence showing that other homeowners have the same thing you have, and that the association has not pursued the claims they're pursuing against you against the other homeowners. So the best way to prove a selective enforcement claim is to have photos of the other homeowner's property and specifically showing the same thing you have, same violation that the association is holding you responsible for. Gather photos of that as relates to other homeowners that have the same alteration to their property. So selective enforcement is usually going to be proven by using photographs. Another homeowner asks, how can we remove board members besides recall elections? So there's essentially four ways actually. Number one, winning at an election. Number two, recall, if recall is not an option. Number three, suing in a derivative capacity for an injunction to remove the board member. And number four, filing a criminal complaint wherein the board member is arrested. And there will be a vacancy, and the vacancy will likely need to be filled. So those are, generally speaking, the four main ways to remove a board member. Another homeowner asks, is board authorization needed to have contracts approved? Well, that's an interesting question. So it may vary depending on the association's governing documents. Generally speaking, you are going to need approval from the board members before an association enters into a contract. And there's actually been some changes on that as it relates to inspections and engineering contracts that were brought into law just this week by Governor DeSantis. And there is now actually a way to undo contracts with engineers if certain disclosures are not made. And we can discuss that in a much deeper way at the next webinar. But yeah, absolutely. Generally speaking, you do need the board members to approve a contract. Some association governing documents do give the board president unilateral authority to enter into contracts. So as it was mentioned earlier, look to your governing documents to see what it says about that. That's a very good starting point for 90% of any question that's asked within the association context. Another homeowner asks, what are the legal limits on director terms? That was actually amended not too long ago as well. I believe somewhere between 3 to 5 years ago, they implemented 8-year term limits. There's much confusion about whether you can be grandfathered into that. And that will, once again, depend on what your declaration provides and whether it has Kaufman language or not. But generally speaking, the new term limits as it relates to Florida statutes is now you have an 8-year term limit as a member of the board of directors. Another homeowner asks, is a board required to have an open meeting as it relates to special assessments? The answer is yes. You are required to have an open meeting. As I mentioned earlier, the only exception to an open meeting is when it's an attorney-client privilege meeting, which is usually the board and their attorney. Everything else must be an open meeting within the association context. Another homeowner asks, what are legal steps that a homeowner can take to adjust abusive or rogue HOA boards? Well, as I mentioned, the most powerful tool is winning at the election. If you can't win at the election, you need to recall those board members. If you can't recall those board members, you may need to sue in a derivative capacity on behalf of the association and claim that those board members have breached their fiduciary duty. If the association is doing something specifically abusive towards you, you may have your own cause of action against the association for things like selective enforcement or for breach of the governing documents, but you need to try to take control of the board. Another homeowner asks, how do you request an audit of a treasury monthly report? Well, you can request an audit essentially by requesting an inspection of association records. You can demand all of their bank statements for the past 12 months. And you can either audit it on your own or you can take it to a forensic accountant. There's several companies out there that offer these sort of services. And you can utilize their services to audit the association's financial statements. Oftentimes, when an association is doing something improper, it's not going to be rocket science. It's going to be very clearly visible on the bank statements. You're going to see a board president or a board member write a check to themselves. And that's a big no-no. You cannot do that. So oftentimes you'll be able to spot it on your own. But if you do need the help of an expert, you can certainly hire a forensic accountant to review all the association's financials and identify any irregularities in the financials. Another homeowner asks, what are the average length of a homeowner versus HOA legal dispute? Very good question. So it's going to depend. Okay, and I'm asked this question all the time. So as it relates to a property damage dispute, so if it's specifically something to the extent of where the association has damaged your property as a result of a common element pipe leak or a roof leak or an exterior wall leak, and you have tens of thousands of dollars of damage in your home, and you have to sue the association for that property damage, usually those disputes are going to be covered by insurance, and usually the insurance company is going to want to do some discovery. And I would say 90% of the time, maybe even more than that, these issues are resolved at a mediation once the discovery has been completed. So I would say on average, as it relates to property damage disputes, the easiest ones can be resolved somewhere between 4 to 6 months. The more complicated ones can vary and range somewhere around 12 to the most complex ones, maybe going all the way up to 18 months. So very general ballpark range, depending on the complexity of the dispute, depending on the aggressiveness of your association or their insurance carrier. It could last somewhere between 4 and 18 months, depending on all those factors, as well as the judges. Judges in different municipalities and different cities have different caseloads. In the bigger, more populated cities, I can tell you, for example, in Miami-Dade County, each judge has about 2,000 cases. So those cases are going to move much slower than, for example, Pasco County, where judges have much lower rather caseload than the ones in Miami-Dade County. So it's all going to vary depending on several variables. As it relates to the more transparency or violation or association non-compliance disputes, everything else outside the scope of property damage, those tend to last generally a little bit longer depending on the complexity of the dispute. I would say if the dispute's going to be litigated within the association context outside of property damage, you're probably looking at a minimum of about 6 months of litigation. Now, those are oftentimes not covered by insurance. So once again, it all depends on how aggressive your association is. They're going to have to come out of pocket from the common fund to fund the litigation. And those can last somewhere between, I would say, 6 to 18 months as well. And once again, most of the time they settle at mediation. Those oftentimes become a little bit more contentious, but and the reason why, so you all know, they become a little more contentious because insurance money is not involved. It's association money that's involved. So the association tends to fight those a little bit harder as opposed to the insurance claims where the insurance company has more of a say in what happens in the case. And oftentimes insurance companies don't want to unnecessarily spend money, so they'll try to settle the dispute earlier on, as opposed to an association who may be a little bit more stubborn, and the board of directors may be a little bit more stubborn and may want to pursue a more lengthy litigation. Another homeowner asks, what are the liabilities for a board not providing requested documents? Well, as I mentioned earlier, as it relates specifically to inquiries, there is a penalty. The penalty is the association losing the ability to recover attorney's fees. As it relates to documents, there's actually a fine. There's a $100 a day fine. I believe it's up to 10 days. There's a $1,000 fine, and ultimately, if they don't pay that fine, you can sue them to recover that fine, and also you can recover all attorney's fees. So there are penalties in place if an association does not disclose the information that they need to disclose. Another homeowner asks, HOA fees are too high, and I'm sure many homeowners can agree with that sentiment. What are the board's limitations on setting them? Well, that needs to be set at the annual budget meeting. So that needs to be addressed and passed at the annual budget meeting. In terms of what you can do about that, as I mentioned, you can get on the board in order to make sure that the money that the association is spending is being efficiently spent. And if you cannot do that, you can investigate the association and ultimately find where the money is going by reviewing their financial records. Another homeowner asks, how often must updates be reviewed or revised? I presume that means updates in the law, whether they must be reviewed or revised by the association. So slightly of a more complicated answer than one would expect. So that's going to depend on, once again, what the language is in your governing documents, whether there is or is not Kaufman language. Just because a new law is passed doesn't 100% mean that that new law is going to impact your association. Some of the older associations, maybe the ones that had their declarations written in the early 80s or in the late 70s, those often don't have the Kaufman language, and it leads to an odd result where the statute from the time where the declaration or the association was created would actually apply as opposed to new statutes. So there is no requirement per se where associations must inform the homeowners of the new laws. Generally, that can be completed by submitting associations written inquiries or simply reaching out to the board and asking them to hold a public meeting where the updates will be discussed with the homeowners. And I'll answer one more question. Let me take a look here. A homeowner asks, when an HOA breaks their own bylaws and tries to enforce rules anyway, what are your rights? So as it relates to HOAs, okay, the dispute resolution clause in the statute provides that before you can sue an HOA as it relates to violation of the covenants, you must offer dispute resolution. You must offer mediation. You have to send what's known as a statutory offer to mediate letter. The association by law will have 20 days to agree to mediation. The penalty for not doing so, once again, is the loss of the ability to recover attorney's fees. And the association must mediate the dispute with you within 90 days. Upon completion of the mediation, the issue will either settle or not settle. If the issue settles at mediation, well, that resolves the dispute. If the issue does not settle at the mediation, now you have what's known as legal standing to go ahead and sue the association. Your remedy for an association not complying with the governing documents is to sue them for damages. And you would sue them ultimately under a theory of breach of contract. The covenants are a contract between the homeowners and the association. Both parties can hold each other to those obligations that are written expressly into the contract. So with that being said, thank you everyone for joining this webinar. We will have many more webinars to come as it relates to legislative changes, as it relates to ongoing issues within the association context. We're also working on setting town halls with the different municipalities. So if you are able to reach out to your local politicians and you feel it would be helpful to have a town hall to have more of these sort of issues addressed and to receive more information, I'd be happy to do that with your local politicians. We are working on that in several municipalities all across the state of Florida in order to educate homeowners in this way to let them know what tools they have at their disposal against their HOA. So once again, thank you for joining. I really hope I was able to help many of the homeowners that attended. I hope I was able to give you all tools to use against your association in these disputes. And if you feel, once again, that this was helpful, I encourage you and would be very appreciative of you all leaving us a positive Google review with what specifically was helpful from this presentation. So thank you all, and I look forward to continuing to represent and help homeowners in dealing with disputes with their association. Take care and have a great rest of your day.